Members, good morning. It's the meeting of the Bills Committee on Air Pollution Control Amendment Bill 2024. This is our third meeting. We hope we can finish clause-by-clause scrutiny today. And at the last meeting, we received 5 submissions. They were supportive of the amendment. We urge the administration to provide a written consolidated response as soon as possible that will address members' concerns. On the 10th of January, the administration has already provided a written consolidated response. I'd like to ask the administration to take us through the response. I'll see if members have any questions to ask. Afterwards, we'll resume clause-by-clause scrutiny. In attendance today are Mr. Alan Low, Deputy Secretary for Environment and Ecology, Dr. Sunny Zhang, Assistant Director of Environmental Protection, Mr. Alan Lai, Senior Government Counsel. We have other representatives as well, so I'd like to give the floor to the administration to take us through the paper. Thank you, Chairman. We provided 2 papers to the Bills Committee. Based on the views expressed by members on the 10th of January, we have already made some supplements. Well, I'd like to, first of all, respond to members' concerns in relation to the commencement date. It is the 11th of April as set out in the bill. Some members asked whether it is possible to advance the commencement date. The purpose is to put in place the relevant amendments as early as possible. We already stated what we think. Our policy intent is to give effect to the amendments as soon as possible, especially in relation to the amendments around on the unlicensed specified processes. However, we need to give sufficient time to the Bills Committee to scrutinize the bill. We are willing to work with members. It's equally important to point out that a fixed commencement date will reduce uncertainties on the part of the industry. There will also be less inconvenience. This is especially true in the studies in relation to air quality objectives, AQO. That's exactly why we will keep the commencement date to the 11th of April. Depending on the progress of the Bills Committee, if members have further views, we are happy to discuss with members. In relation to updating AQO, at last meeting, members requested further information. Say the findings of the public consultation, as well as the considerations or factors in the amendment. We have consolidated the views of experts in the trade stakeholders as well as the public. We have also had regard to the local situation. The WHO issued an air quality objective guideline. Members asked why we didn't adopt the final goals of the WHO. If you refer to the WHO air quality guidelines, they propose the relevant districts to have regard to the socio-economic development and the general situation of a country before practical suggestions are made. We have already factored all these into the bill. Comparing with other advanced economies in Asia, say Japan, Singapore, our standards are actually on the same par with theirs. In the past 10 years, there's a significant improvement in relation to the air quality in Hong Kong. One of the members of the public mentioned the issue of nitrogen dioxide. In the past 10 years, there's been a drop of 40% in relation to nitrogen dioxide. It is expected that in 2030, nitrogen sulfur, nitrogen dioxide, carbon monoxide, lead, RSP, FSP, we expect that we can meet the relevant goal. In relation to ozone, it is a type of secondary pollutants under the impact of photochemical pollution. We will enhance our efforts in this regard, and we will also work with Guangdong, Macau, in order to improve air quality in a continuous manner. In the next round of the review of AQO, we'll continue to explore if there is any room to tighten the requirements in relation to ozone and nitrogen dioxide. At last meeting, members also raised issues in relation to legal and drafting matters. I will ask the DOJ to supplement in a moment. In relation to concrete mixers, is it possible to install GPS devices onto the trucks in order to enhance the law enforcement actions? There is also the issue of cement slurry dropping from cement trucks or mixers. Now I'd like to ask the DOJ to respond to legal and drafting matters. Thank you, Chairman. Clause 30C specify person in relation to the scope. It refers to the person carrying out the operation or the process. We need sufficient evidence before we make a decision. According to the administration, in general, if the operator conducts a specified process, the administration considers the operator to be the specified person. If the operator conducts the relevant specified process, then the notice will be served on the operator. However, for those who are not involved in the conduct of the specified processes, such as the security guards, according to the administration, they don't fall under the interpretation in Clause 30C. They aren't the specified persons. In relation to the drafting, the Chinese version of subject premises under Section 30C, I'll give the floor to my colleague. Thank you. We want to clearly bring out the message of closure notice. If we need to delete the words as suggested by members, that is in respect of in the English version, we'll have to add more words to quantify the subject premises, and then there will be two groups of in respect of in the Chinese version. This is a matter of translation. We want to make it easier to understand in order to enhance clarity in the Chinese version. That is more easily comprehensible by users. Thank you. Under 30E, brackets 2, regarding service of closure notice on a particular company that is a registered non-Hong Kong company, one can invoke 30E 1B or 1C to serve the copy at last known place of business or residence. In the case that a company is a registered non-Hong Kong company, one has to provide an additional way of contacting the business. That is one more way of delivery or address. Yes, this is our introduction. I'll see if members have any questions. Based on the 5 submissions we have received, do you have anything else to add? DS? Actually, most of the submissions are supportive of the amendments. In some submissions, there were questions about the considerations in relation to AQOs or the public consultation. There's much repetition in all the 5 submissions. We don't find it necessary to spend extra time to take members through the submissions. 3 members have pressed the button to request to speak. Mr. Chen Xiu-hong, Mr. Tony Tse, and Dr. Frankie Ngan. Dr. Ngan, please. Thank you, Chairman. I have several follow-ups. In relation to concrete slurries dropping from concrete mixers, in the past 3 years, there were a total of 59 joint operations, but there were only 2 prosecutions. Of course, there were fixed penalties of 364 in total. But not all of the fixed penalty tickets are in relation to cement trucks. There were only 2 prosecutions over a span of 3 years. There were a total of 59 joint operations. In relation to reports, the Highways Department and the FEHD received a total of 82 reports in relation to concrete slurry on the road. In the Yaotong district, there were 16 cases. I hope the administration will take a more proactive approach. In 14, the administration said that they would include this remark in the code of practice or the internal guidelines that prosecutions not be made on the offender. People don't want to be prosecuted and put up their defense afterwards. So can you make it clearer in the bill? That is, at the invitation of a public officer, then someone entering the premises may be exempted. Can you make it clearer in the provisions? Thank you. We need to enhance enforcement action. We'll discuss it with the relevant enforcement agencies. Yes, prosecutions are important. It is important to achieve deterrent effect. We will follow up on this, and we will also relate this matter to the law enforcement agencies. regarding paragraph number 14. If someone enters the enterprises upon the request of a public officer, will these persons be held liable? Well, we think we need to strike a balance. If someone finds it necessary to enter a premises, there may be a wide range of different reasons. It's difficult to list out all the reasons. In any event, we'll go back and study members' views.
Chairman, I'm talking about people who are invited by public officers to enter the closed premises. For example, there may be a fire, and then they invite someone to go inside and maybe open one of the doors. So these are the people invited by the public officers to enter the closed premises. Yes, point taken. I think the example quoted by Dr. Frank Yan is understood by the administration. Next, Mr. Chan Xiu-hong. Thank you, Chairman. I would like to follow up on a few things. First, about the ozone as a secondary pollutant. I understand the administration's explanation, but I think the critical point is that at present, for the background pollution in the whole region, so it may not be meaningful to tighten the requirements because the background pollution is quite intense. So that's why I understand that you try to set a new parameter and you look at the efforts put up by the governments of Hong Kong, Guangdong, and Macau in conjunction. But I think the core of the matter is how we can enhance collaboration amongst the three administrations so as to improve the air quality in respect of ozone. And then the Hong Kong government can consider about tightening the targets. I think this is something of concern to the members of the public, and we want to have a timetable. I want to know whether all the administrations have the determination to do so. I know the Guangdong government is determined to do it. But because of the activities increased in the region, it may not be able to achieve the targets that we want to achieve. So I would like to hear more about your collaboration with the Guangdong and the Macau government. Do you have confidence, say, in the coming 2-3 years, you can try to improve the air quality for the region as a whole? So this is the first question that I want to ask. Colleagues from EPD, thank you for the question. As we have explained before, ozone is a complex matter. Within a short period of time, it may not be easy to see reduction in terms of ozone pollution. So it depends on the pollutant that we want to reduce. If we look at the whole Guangdong area, if we want to reduce NOx, but for some of the places in Guangdong area, they may not be reducing NO2. And for the collaboration, we actually have an air quality task force concerning the three administrations, and we have a cross-boundary cooperation in regard of the cross-boundary vehicles. We want to devise a specific work plan, but in the near future, say in 1 to 2 years, it may not be easy to resolve the question of ozone concerning the region. But nonetheless, the three governments do have the determination to tackle the problem. Thank you. I understand that. I think you have to put in more efforts and then liaise with the two administrations in Guangdong and Macau so that we will be able to achieve a better environment. The second question is a follow-up on the question I raised at the last meeting about the definition of premises. I understand that for the premises, you have added ships and barges. So my question is to understand, after the amendment of the definition of premises, would it be usable? Because in the past, we only govern about people who are law-abiding. You gave them a license for the specified process, and you have a designated area for them, and that will be the premises, and they can conduct a specified process there, and you impose requirements on them. But if there are people who want to make use of the loopholes and they park a cement vehicle in front of the premises, what will happen? And you are saying that if the vehicle is parked there and if it is linked to the facilities within the premises, and they may try to bypass the total capacity requirement. Your response is saying that if they have facilities that are parked outside the premises but they are connected, then the administration will take enforcement action according to the license conditions. But they haven't obtained a license for that. They just park the vehicles outside the premises, but then they are connected to the equipment in the premises, so they are willing to receive illegal parking fixed penalty tickets. Well, I want to use this example to illustrate the problem and how you can address the matter after the law has been amended. You can address the problem of operation at sea, but how about illegal parking outside the premises? So your question, if there are equipment or vehicles that are linked to the premises, how are we going to address that? And they will not reach the total capacity of 50 tons. Well, when we issue the license, we will have licensing conditions. If we notice that if they are going to do things that way, we will specify in the license that if there are facilities linked to the premises, then we will address them. We will talk about linkages of such equipment later on. If they do not operate according to the license conditions, then we will take enforcement action. So we will take action according to the licensing requirements. If there are cement vehicles parked outside the premises and they are connected to the equipment within the premises, that is the premises or specified process, that is not allowed under the licensing conditions. And then we can prosecute them if we have sufficient evidence. Well, Chairman, the critical point is that they are doing so deliberately. So they do not reach the total tonnage of 50 tons. But how can you tell whether the operation is connected or not and included? So what you're saying is that the operation within the premises is not licensed. Yes, what I'm saying is that they do not fulfill the 50 tons requirement, so they don't need to apply for a license. It's only some 40 tons. And then they make use of mobile vehicles parked outside the premises, but connected to the premises to conduct the specified operation. So how are you going to address that? Because when you issue the license, you specify what is the premises area, boundary, etc. But there may be people who do not apply for your license and then they take illegal action. So I don't want people to make use of the loophole. So can you change the wordings of the legislation, just like the operations at sea? Can you say that for the specified process in any premises, if they are connected to the specified process, they will be counted in terms of the total capacity? Because what I'm saying is that some people, they do not apply for a license from you, and then they make use of special devices or equipment outside the premises so as to bypass your 50 tons requirement. So you are talking about the cement operations total capacity below 50 tons, how the administration is going to tackle it. And the second question is, how are you going to measure the tonnage of 50 if they make use of mobile devices connected to the premises? Well, if they have not applied for a license, that doesn't mean the cement works are not governed, because according to the air pollution legislation, another piece of legislation, they will be governed. because if they don't have a license for the premises, we do have another piece of legislation governing cement works. If they park cement vehicles outside the premises, we will ask colleagues to go and collect evidence, and then we'll try to count the vehicles which are linked to the premises. If in total they meet the 50 tons requirements or they bypass that, then we will be able to prosecute them for operating or breaching the licensing conditions. So for the other legislation, the air pollution control, construction dust regulation, that will be able to address the problem. Well, I would like to ask the DOJ. So for the definition of premises, it includes, any premises and installations. So for installations, would it be able to cover the scenario that I just mentioned? So you may be able to count the number of cement vehicles connected to the premises. Would that be covered under relevant plant? You're saying that you may have legislation that you can rely on to prosecute them. But my question is this current drafting sufficient for the administration to take enforcement action? Thank you for the question. I think member is asking about the definition of premises. It is a part of any premises or a part of any place, building, or relevant plot. For relevant plant, we don't have another definition for it. So the general understanding will be applied as regards the meaning of relevant plant. So the question is whether relevant plant will cover devices connected to the premises. So it depends on the situation of individual cases. Well, if we look at subsection A2, it includes or any part of a place, building, or relevant plant. So there is a meaning of continuation there. So what I'm saying is that we have to look at the actual situation, and then the enforcement officers and the court will make a decision on that. Just a clarification. For subsection A1 and A2, you use the word "and" to connect the two parts. So it is not the word "or." So if we look at subsection 3A1, it is a place, building, or relevant plants, and then "and" subsection 2, a part of any premises or a part of any place, building, or relevant plant. So for the two combined together, does that include devices or plants inside and outside of the premises? Is that the case? To prevent misunderstanding, can you revise the wordings here so that all the relevant plants, be it inside or outside the premises, will be included? So I hope the administration will go back and consider this so as to address the scenario that I have just talked about. Thank you, Chairman and members. Why do we use the word "and" here? Because we want to have the meaning of include here. We are not listing all the scenarios. We're just listing some of the examples here. That's why we have the small numeral A1 and then A2. So the interpretation is that it is not necessarily to look into subsection A1 and 2 together to form the meaning of premises. Either one of them will be counted as a premises. That means if it is a relevant plant or if there's any part of a place, then both of them will be included and counted as premises under this definition. Because it is not non-exhaustive way of drafting. So that's why we use the word "and" here. But it is not exhaustive. Well, I recall that you have explained about this at the last meeting. Next, Mr. Tony Chair.
Thank you, Chairman. I'd like to follow up in relation to concrete mixers. That is installing a GPS system on the concrete mixers. On monitoring cement slurry, it is not helpful. Just now, members spoke on it. It is not uncommon. Of course, there were joint operations, there were prosecutions. All these took place after the incidents had happened. So the administration said that one way doesn't work, but the public wants to take preventive measures. How can we prevent these incidents? We don't want to take legal enforcement actions after something has happened. Penalty isn't the most effective way. It leads to a waste of many public resources. So has the administration thought or considered how they should approach this issue? We should adopt a more positive mindset. EPD. Thank you, Chairman. Thank you, Member, for your question. Indeed, the GPS doesn't help with the issue of cement slurry. However, we do have measures against targeting cement slurry. As we mentioned in our response, we already required the installation of devices to prevent slurry from dropping from cement mixers in the Yaotong district. In relation to slopes, we believe this measure will prevent cement slurry from dropping from cement mixers when the mixers go uphill. We'll continue to discuss it with the industry, enhancing this measure when the relevant licenses are renewed. Well, this is a good method as we can take preventive measures. I'd like to know more about the installations or devices. Is it easy to identify the devices? Can we tell whether they are effective or not? Sometimes installations or devices are put on a vehicle, but when the devices go out of order, we don't know. You can't take all the vehicles for inspection whenever you take legal enforcement actions. Well, as I said, we'll discuss it with the trade. We'll make continuous improvements in the design of the installations. We've heard members. We'll take steps. We'll put in place pilot trials to make sure this method is effective. Well, like lamps, you should make it easy for law enforcement agencies to tell whether an installation is effective or not. Well, I have a question. What if a driver on purpose switches off the installations? Is it regulated under the regulation? Take the Yaotong district as an example. We have already added this requirement. If someone doesn't install the device or the installation, basically, the licensing conditions are breached. Then we can take enforcement actions and we can collect evidence to do so. Mr. Chen Xiu-hong. Thank you, Chairman. I'd like to follow up on 30C. That is the scope of specified person. under Section 30C. I understand the administration's explanation is clear. However, if the operator as a specified person suspends the specified process according to the closure notice, in accordance with 30H, one cannot conduct specified processes, otherwise one is subject to a penalty. One of the specified person is the boss. If a specified person conducts specified processes when the venue is subject to a closure notice, then how are you going to prosecute the specified person? The boss or the employer may have a reasonable excuse. For example, he has already ordered the workers not to conduct any specified processes. So what if the worker still continues with these specified processes? So do you mean the worker doesn't obey the directions of the employer and the worker still carries on with the specified process regardless? Well, I mean, what if the workers somehow didn't receive any notice, or if the workers continue with conducting specified processes regardless of the instruction by the employer? The employer may have a reasonable excuse, say he has already ordered the worker not to conduct specified processes. So what if the worker continues with the specified processes? How are you going to prosecute the workers? In our ordinance, the person operating in the specified process is considered a specified person. Then in that case, we will see who is the person directing the worker to conduct the specified process. And in the circumstances where the worker isn't ordered to do so, but then the worker is conducting the specified process, then the worker still fits the definition of a specified person. And that's exactly how we'll approach this situation. We want to target the mastermind, so to speak. But if the person behind says that, well, I didn't give any directions, I didn't give any orders, the worker simply carries on with the specified process regardless, then in that case, probably the employer may be able to get away with the non-compliance. But if the worker still carries on with the specified process, then the worker is still a specified person according to the ordinance. In many cases, we'll see who the mastermind is, and that is who is in control of the situation. In other words, when these incidents happen, then you prosecute the employer first. And when the employer has a reasonable excuse, say when I lock the premises, but then someone breaks open the lock and enters the premises with the statutory defense, then the employer isn't subject to prosecution, but then you will prosecute the worker for entering the premises on his own. Then you will invoke other ordinances to prosecute the worker. Yes, that is correct. Say, how long after the issuance of the closure notice will the premises be locked? Because this is a very clear action. The worker will definitely know that the premises is locked in this case. Well, as we said at the last meeting, we'll do so as soon as possible. When the closure notice is issued, when it is served on the specified person, we'll lock the premises as soon as possible. Okay, before we proceed to clause-by-clause scrutiny, I'd like to ask members once again, do members have any other questions on the two papers submitted by the administration? No? Then I'd like to ask the administration at this stage. Do you need to make any further amendments? Do you have any considerations? At present, no. in the stage of clause-by-clause scrutiny, we'll probably have to move amendments. We'll come to that at that stage. All right, let's resume clause-by-clause scrutiny. At last meeting, we were up to 30J. Then we'll start from 30K. That is in the blue bill C229. Prohibition on removing or defacing closure notices. Thank you, Chairman. As the Chairman said, while a closure notice issued in respect of any subject premises is in force, a person must not remove or deface any copy of the closure notice affixed at a place under Section 30D(3)(b. A person who contravenes subsection 1 commits an offense and is liable on conviction to a fine of $200,000 and to imprisonment for 6 months. In other words, if someone removes or defaces the closure notice, someone breaks the law and is liable on conviction to a fine of $200,000 and to imprisonment for 6 months. Any question, members? No. Let's move on to 30L. During the period while a closure notice issued in respect of any subject premises is in force, a person must not break or otherwise interfere with any lock or seal attached to any part of the subject premises under Section 30G(a). Like 30K, a person who contravenes subsection 1 commits an offense and is liable on conviction to a fine of $200,000 and to imprisonment for 6 months. Any questions from members? I have a question. Can you tell us some real-life examples? Well, I understand what breaking a lock means. What about interfering with any lock? What does it mean? Well, it means when you damage a lock, when you break open a lock. We mean to lock up a premises. However, when you damage the lock or damage the seal, then it means interfering with the lock. Well, I mean what breaking a lock means, but what about interfering with the lock? What does it mean? If there is a seal, and if you damage the seal, then it is a type of interference. Well, do you mean affecting the appearance or the functionality of the seal, or using paint to paint the seal? Well, I'd like to ask about the term remove. It's remove in English, that is 移除 in Chinese. What if I'm moving the notice from a place to another, say to a less conspicuous place? Is it breaking the law? Well, in relation to moving the seal or the closure notice from one place to another, we'll have to take into account the actual situation. The law enforcement agencies will have to have regard to the actual situation on the spot. There's a gray area here. Do you allow any moving of the seal or the notice? If you remove a notice, of course it breaks the law. But what if you simply move the notice from a place to another? Does it break the law? Well, if you say the court will make the decision, then does it mean that all persons who move the notice from one place to another will be subject to prosecution as well? If we put the notice in a conspicuous position, say on the door of the premises, if one removes and disposes of the notice, of course, it's removal. If one takes the notice and places it in another place, of course, it is a type of removal as well, as premises have been locked up and one cannot conduct specified processes anymore. If you move the notice and put it on the ground, for example, then it is a type of removal as well.
好啊，容易。
Chairman, I have some follow-up questions. Now you're saying that a person would remove the notice. So if it is a human action, then it may be in breach of the bill. But if it is not an act by human beings, say if there is heavy rain pouring, the color of the notice faded, then how are you going to deal with the situation? So what kind of paper are you going to use for the notice? Well, thank you. This is a very good question. Actually, we have other license issued by the EPD as well. And usually we will put the notice inside a transparent plastic folder, and then it will be posted on the front door. Some people may even tie it with a piece of plastic string. So it is not just one piece of paper that is affixed to the premises. So it may be, for example, laminated, etc., and it will not be damaged by rain and wind. So we can see that for a lot of construction companies, if they receive notices or licenses from us, which needs to be posted, they would put them up nicely. You're talking about what others will do. So what will EPD do? Well, we'll be doing the same thing. If the notice is affixed to the door, we will put it inside a transparent plastic folder first, so that it will not be affected by rainwater. I think the scenario may not happen, but would there be another scenario? They may not tamper with the notice or the seal, but however, they may use a very big object to block the notice so that other people would not know that there is a closure notice. So would they be covered by 30K? Well, then I think it will be interfering with the notice or seal. As Mr. Lai has pointed out, even if they don't touch the notice, they just try to cover the notice, say with a big piece of cloth, trying to block the notice, then it is a deliberate action, and I think it will be counted as interfering with the notice. DOJ? Yes, Chair, we share this view. Chair, a further question. I think if we look at 30K and L, K is on prohibition of removing or defacing the closure notice, and L is prohibition on breaking or interfering with the lock or seal attached to subject premises. When you talk about interfering, my understanding is that you have to touch the lock or seal, but if you're trying to cover it, then it may not be interfering. Do you want to reword it as deliberately or attempting to block or cover the notice? Do you need to add such wordings to it? Because interfere means that you really have to touch the lock or seal. But if you're trying to cover it with some other objects, it may not be counted. Well, I think we have to look at also the English version. Well, thank you for the comments. Our policy objective is very clear. I think we'll go back and discuss with the draftsman. Or Mr. Lai, do you have anything to add? Thank you, Chairman. I think for interfere or 干擾 in Chinese, the meaning is clear. It has a rather wide meaning. It is meaning that the lock or the seal will not be able to perform their function. That will be counted as interference. Interfere means that it will not be able to perform its function. So I think it is rather difficult to be exhaustive and spell out all the different scenarios. Well, I think we have just looked at another piece of legislation about interfering with vehicles. I think there it is very wide. It has a very wide scope. You do not have to touch a vehicle in order to interfere with it. So could you please go back and look at the wording? Yes, please go back and look at it to see whether the word will be wide enough to cover different scenarios. Mr. Chen Xiu-hong. Chairman, we've been talking about 30K and 30L, but if we go back about the policy intention, you want to post a closure notice. What's the purpose of that? You want to allow people to be aware that the premises is being closed at a prominent place. So you put the notice as a prominent spot of the premises. So I think the scenario mentioned by Ms. Eunice Yong and the chair can happen because you choose a very conspicuous place to put up the notice, but then someone may put a cupboard in front of the notice. So does it count as remove or defacing? Maybe not. But would it be considered as interfering? Maybe yes. So for 30L, you said prohibition on breaking or interfering with the lock or seal attached to subject premises. But would it be necessary to add interfering in Section 30K as well? Because Ms. Yong has pointed out that when we look at other pieces of legislation, the definition of interfere is much wider. If someone deliberately try to block the closure notice so that it will not be seen by other people, it should be considered as interfering with it. So would you consider adding interfere, the word, in Section 30K? DOJ? Chairman, as members have proposed, if we include interfere in 30K as well, then it is the same action. It may not be necessary to do so. We have already included the word interfere in 30L, so maybe there is no need to repeat it in 30K. Excuse me, Chairman, I want to see if my understanding is correct. For 30L Section 1, it is stated clearly that a person must not break or otherwise interfere with any lock or seal. They are not talking about the closure notice. Is that my understanding? Is that correct? But for 30K, it's about removing or defacing the closure notice. You just say that a person must not remove or deface the closure notice. In 30K1, you are saying very clearly that a person must not remove or deface any copy of the closure notice. Can you repeat that in L? Well, Chairman, I think these are objects trying to enable the implementation of the closure notice. Do you think you should use similar wordings to cover the two sections? Yes, thank you, Mr. Chan. We'll go back and look at the two subsections. Let's move on to 30M. It is on the defense. For Section 30M, it is to assist 30I, K, and L. These are defenses for the purpose. That means if a person has charged with an offense under Section 30I, K, or L, they can use reasonable excuse for the contravention of the sections. For 30M Section 2, it is stated that the burden of proof. So the burden of proof will lie with the prosecution. And the prosecution has to prove that the contrary is not proved beyond reasonable doubt. Legal advisor. For 30M, we have supplementary information for members. 30M is a defense under the bill. It is a reason for defense. We have written to the government to ask whether the reasonable and the mistaken belief under common law, can that be also used as a defense? The administration has responded to that to say that if a person is charged under 30I, K, or L, so apart from using the defense under 30M, they can also use honest and reasonable mistaken belief as a defense. And the administration has also pointed out that the burden of proof will rest with the prosecution. And the prosecution will be required to prove the contrary beyond reasonable doubt. So the burden of proof is the same as that under Section 30M. This is for members' reference. If there are no further questions, let's move on to 30N, administration. Last time we talked about the issue of the closure notice, and we also have a mechanism whereby the authority can cancel the closure notice. This is stipulated under 30N. For 30N1, it is stated that the persons who have an interest, that means the interested parties, they can apply in writing to the authority for the cancellation of a closure notice. So when can they apply for that? It is stated in 30N bracket 2. If the authority is satisfied that according to Section 2A, B, and C, then the interested parties can apply for a cancellation of the notice. A is that the specified person is already a holder of a license for a specified process. Then they can apply for a cancellation. 2B says that if the chimney, relevant plant, machinery, or equipment used for the conduct of the specified process has been removed, that is also a reason for applying for cancellation of the closure notice. And Section 2C is that the subject premises have been abandoned and no specified process is being conducted on the subject premises. That is also a reason for applying for cancellation of the CN. So I have explained about Section 30N bracket 1 and 2. Mr. Tony Jett. Thank you, Chairman. For Section 30N, it touches upon subject premises which have been abandoned. My impression is quite unclear. What is meant by have been abandoned? There is a time factor. Why do you use such wordings? You are saying that the specified process is no longer being conducted there. Can you explain about that? Mr. Tony Jett is asking about 30N, Section 2C. Well, perhaps let me explain why we have Section 2B and 2C. 2B is that the equipment, machinery, chimney, etc. have been removed from the subject premises. But there may be a scenario whereby the person concerned do not want to remove the relevant plant, so they just go away and leave the premises and the plant there. They don't conduct a specified process, but they just go away. Then we can consider that as the premises being abandoned and no specified process is conducted. We want Section 2C to cover a scenario whereby the specified person just go away without removing all the equipment there in the premises. Then the premises still contain the equipment like chimney and machinery. So when we think about Section 2C, we want to add Section 2 bracket C to cover the situation whereby the operator, the specified person, just go away, leaving all the equipment and everything behind. So the premises will become abandoned. So that's the reason for including this provision.
Chairman, I understand that. But should we use the word abandoned in the English version? The word "feng-hei" in the Chinese text means that a place has been abandoned for a period. It means no one has used that premises for a period of period. So in this context, in this situation, how will you understand this word? Well, in bracket C, in relation to the word "feng-hei" in the Chinese version, the interested party is the owner, for example. If someone rents a place to another person and when that person has gone away, when someone doesn't pay the rent but conducts the specified processes, and because premises are subject to a closure notice so that the owner cannot do anything at all, then they will approach us. For example, when a place has been abandoned or when premises are unattended, no one is inside the premises, then one can apply with us to cancel the closure notice. So we don't want to set in stone a time frame, say 2 weeks or 3 weeks. When an interested party makes an application to us, then we consider whether the application in question is reasonable or not. When you add the word abandoned, that means premises are not in operation, and that is the most important point. I'm not saying that we must have a time frame, but when I read this subsection, in my opinion, there may be confusion. In the Chinese version, the word "feng-hei" that is abandoned. In the English version, it means, to me, that a place has been abandoned for a period of time. If there are guidelines within the administration, then there is no problem. However, if premises are no longer in operation, then someone may apply to the administration to cancel the closure notice. But if you use the word "feng-hei" in the Chinese version that is abandoned in the English version, then I have a question. I have doubts. Well, in English it means unattended or abandoned. Well, we shouldn't use the word unattended, it's abandoned. Well, I just want to make my point that these words may convey the meaning that a place has been abandoned for a period of time. Well, thank you. Probably we can proceed to brackets 3 and 4. The authority may, on the authority's own initiative, cancel a closure notice if satisfied that the subject premises have been abandoned and no specified process is being conducted on the subject premises. Brackets 4. When the interested party makes an application, and if the EPD doesn't agree and has to maintain the original decision, then the authority must serve a notice of refusal on the applicant as soon as reasonably practicable and provide the reasons for refusal in the notice. And these are brackets 3 and 4. in relation to 30N. Any question for legal advisor? Thank you, Chairman. Members can see that a specified person can make an application, or someone who has an interest in the subject premises. There is no definition under this section. So in relation to any person having an interest in the subject premises, in the administration's response, some examples were given. Say the owner of the premises or someone that has a collateral right in the premises. These refer to persons having an interest in the subject premises, so I'd like to seek clarification from the administration. What do you expect that person to prove that he or she has an interest in the subject premises? In the ordinance, as we can see under Section 30N, you set out what circumstances allows you to cancel the closure notice, but there is no reference to any person having an interest in the subject premises, or under what circumstances will one person be accepted as a person that has an interest in any subject premises. In general, for a person having an interest in, it refers to an owner of the subject premises or someone that has a collateral right that can prove a land interest in the subject premises. One can conduct land search, or by way of documentations, one can prove to us that he or she has an interest in a subject premises. One can come to us, show a rental agreement, show us the conditions, but then the person who rents the premises has gone away. Then that person can show to us that he or she is a person that has an interest in the subject premises. So what if that person is an employee of a company that operates without license, where as an employee in that case, we consider the interest an employee has. What kind of interest does that employee have? The person concerned has to submit documents to prove that that person has an interest in the subject premises. Regarding 30N, any more question? No, then we have finished Section 30. Let's move on to C2233. That is the amendment to Section 31. Mr. Chen, do you want to speak? Well, yes, we'll move on to appeal. That is where we are on page C2233. We amend Section 31 of the Air Pollution Control Ordinance. It is in relation to appeals. Under the Air Pollution Control Ordinance APCO, there are many circumstances under which you can launch an appeal. We have added in this case issuing a closure notice and refusing to cancel a closure notice. So after Section 31(1)(q), we add QA and QB. That is, after a closure notice is issued, you can make an appeal. And after a closure notice, after you refuse to cancel a closure notice, you can make an appeal as well. In Section 31(2), we add subject to subsections brackets 2 capital A and 2 capital B. After issuing a closure notice, after we have issued a closure notice, one can lodge a notice of appeal in the prescribed manner and form within 21 days after the day on which the closure notice comes into force under Section 30F. And in 2B, an appeal against a decision to refuse to cancel a closure notice is to be made by lodging a notice of appeal in the prescribed manner and form within 21 days after the day on which the notice of refusal is served under Section 30 and brackets 4 brackets A. It is in relation to when one can make an appeal. So we have added the two conditions, 2A and 2B. Now that we allow appeals, we set out the period of time in which one has to bring an appeal. And that's what brackets 2A and brackets 2B mean. In relation to Section 31, Mr. Chan, thank you. When appeal may be brought in effect thereof under Section 31, after Section 31, brackets 1, brackets Q, add brackets QA and QB, that is issuing a closure notice and refusing to cancel a closure notice. So why don't you add 30 brackets N brackets 2 brackets A? That is canceling the closure notice. 30 and brackets 2 brackets A. The specified person is the holder of a license to use the subject premises for the conduct of the specified process described in the closure notice. Well, this is a good question. When the administration agrees to cancel a closure notice, why isn't there an avenue for people to bring an appeal? Well, do you mean 30 and 3? No, I mean 30 and brackets 2 brackets A. Let me give you an example. In accordance with 30 and brackets 3, when the administration decides to cancel a closure notice on the authority's own initiative, or if you make this decision based on the request of someone that has an interest in the subject premises, why isn't this decision of canceling a closure notice not subject to appeals? Why is there no avenue to bring such an appeal? Well, we'll go back and consider this point. Thank you, member. For canceling a closure notice on our initiative, there is no appeal mechanism. Yes, I understand your point. I'll go back and study this point. Yes, exactly. I mean Section 30 and brackets 2 brackets A and Section 30 and brackets 3. I'd like to ask, for person using the appeal mechanism, is there any requirement that one has to be a holder of a license or a licensee? There are two situations. One, when we serve a closure notice or when we refuse to cancel a closure notice. That is the person we target. There's indeed an appeal mechanism already in the ordinance, but then our amendments to Section 31 are that we added issuing a closure notice and refusing to cancel a closure notice. Well, that should cover anyone. Is that correct? Yes. Section 31 targets all people, anyone, I mean.
If there are some citizens in a community, they do not like the specified process, and then you have issued a closure notice, and then someone may raise that if the specified process has been stopped and the closure notice can be cancelled, but then the residents in the vicinity may not be comfortable about that, and even if they are not the operator and they are not the owner of the premises, they can also go for an appeal. Is that the case? Yes. I think what you're saying that if a citizen is wondering why the EPD would cancel the CN and they think that the problem is still lingering, then there should be an appeal mechanism for them to go against the EPD's decision to cancel the closure notice. So I think you cannot address this scenario at the moment. So what Mr. Chen is saying is that you should go back and look at it. Yes, we'll do so. Mr. Tony Chair, we are talking about the appeal mechanism here, and it is required that it has to make 21 days after the day on which the closure notice comes into force, and they have to apply for the cancellation of notice within a specified form. So the form is not very complicated, right? Well, the form is existing. It is under the Air Pollution Control Ordinance. So you don't have any problem with the timeline of 21 days. No such problem. It is only a very simple form of 1 to 2 pages, easy to be filled in. And the form has been in operation for some time. Thank you. Mr. Chen Sil-hung. Chairman, to respond to your point earlier, the appeal mechanism is available to everyone, but the condition is that they should feel that if the public officer has taken an action and they feel aggrieved by it, then they can apply for an appeal. And so the citizens near the premises, in the vicinity of the premises, if they feel aggrieved, they can also make use of the appeal mechanism. So Section 31 has been in force for many years and it has not encountered any problems. Is that correct? So you have addressed the chairman's question. So it is open to anyone to use the appeal mechanism. Is that correct? Is Mr. Chan's understanding correct? Yes, that's right. Legal advisor. Thank you, Chairman. On the question raised by members, if you look at Section 31, it is very wide. It is saying that a person may appeal if he is aggrieved by a decision requirement of a public officer. But for the appeal, there is a scope. Under Section 31, it is stated that the person is aggrieved by a decision of a public officer. If they are aggrieved, the grievance should be related to the decision of a public officer. It is not as wide as anyone who feels that he is aggrieved because of anything, then they can make use of the appeal. I think for subsections 31A onwards, there are many different scenarios. Most of the scenarios touch a point about the issuing of licenses, etc. So don't have the impression that anyone who feel aggrieved can appeal. So there are lists of decisions under the section that is subject to the appeal. Yes, that's correct. We understand about that. So that's why Mr. Chan has raised a very pertinent question. He's saying that for section Q, it should be not just confined to QA and QB, there should be a QC. For section 2A and 2B, I noticed that the wordings are different. For section 2B, you use the wording of 21 days after the notice is served. But for section 2A, you only say that the notice comes into force. So it is not being served. Why don't you use the same wording for these two sections? Well, for the closure notice, it is stated in 30F, and it is stipulated there as to how the closure is successfully served. So we have to rely on the wording of coming into force 21 days after the notice has come into force. You may recall that I have mentioned last time that we'll post the notice and we'll also stick the notice to the premises. So that's why when we use comes into force, we have to refer to Section 30F to say when the notice comes into force. So that's why we don't use the wording, the notice is served. At the last meeting, I've mentioned that I may need 3 days to send the notice by post, and then maybe on day 4 I will affix the notice on the premises. So the effective day for the notice is not the 4th day. So it depends on when the notice is being served. So that's why we say that we have to rely on Section 30F to say 21 days after the notice comes into force. So Section 2A is on when the closure notice comes into force. Yes, that's correct. We have to look at Section 30F. So there are 2 conditions. The first one is that the notice is served. The second condition is that the notice is being affixed. Yes, that's correct. If there are no further questions, we'll move on. Section 33, that is about the exercise of the appeal board's jurisdiction. It is saying that if there is an appeal, there has been an established mechanism that there will be compensation, and that is stated in Section 33. This time, we added a scenario whereby if an appeal against the CN is successful or an appeal against refusal to issue the notice, then the appeal board may make an award for the cost, which is a fair and just compensation. So in Section 33, subsection 6, we add a 6A. And there is a Section 6AA and 6AB. You can see that for Section 6A, it is actually in existence under Section 6. We have removed that part, and we now added it as a Section 6AA. So if we refuse to cancel the CN, and if the party's appeal is successful, then the chairman of the appeal can award a compensation if he considers necessary. Do members have questions on this? Mr. Chan Siu-hong? We are saying that we may need to add a section's QC. If the administration will add that, then maybe you also have to mention it similarly here under Section 33, Section 6A. Yes, we understand that. Then we move on to the amendment concerning amendment to Section 37D. It will empower the Secretary, after consultation with the Advisory Council on the Environment, amend any air quality objective by amending Schedule 5 by notice published in the Gazette. Please go on. For Section 33, Ms. Doreen Kong has a comment that she would like to raise. It is in English. She said that for the Section 33, Section 6AB, he said the word was used in the English version. She thinks that the word were should be used instead. Yeah, we'll look into that. So let's go back to 37D. It is stating that the Secretary can be empowered to amend Schedule 5 by notice published in the Gazette. Before we have the amendment of 37D, how do you deal with the scenario? Well, we actually follow Section 7 of CAP 311 to amend the AQO. So every time we have to amend the ordinance, we think that this is a technical amendment. So we would like to make use of this opportunity to empower the Secretary, whereby the Secretary can amend the AQO Schedule 5 by notice published in the Gazette. It will also be subject to negative vetting by the Legislative Council. In the past, we have to amend the main ordinance and will take a longer time. Legal advisor, any question? No, thanks, Chairman. Members, I would like to draw your attention that air quality objective is not a simple matter. To a certain extent, AQO would affect different industries and operations. The government's proposal will make the amendment to the AQO faster than before. Do members agree with that? Do we really want the government to do so quickly in amending AQOs? Chairman, maybe I'll supplement. This legislative amendment is to empower the Secretary for the Environment and Ecology so that he can make use of the subsidiary legislation to amend the AQOs, which will also be subject to the scrutiny of the Legislative Council. I would like to make an undertaking here that we will go through due process consultation, like consultation with the trade, relevant parties, and the Legislative Council before we submit any amendments concerning AQOs. Here you only mention consultation with the Advisory Council on the Environment. We just follow the practice of the existing legislation. Okay, next. Mr. Chan. Chairman, I think you have raised a very important question. On the one hand, we are concerned about air quality, its impact on the community and our citizens. If it is practicable and reasonable, we should try to control our air quality as far as possible. And we have to tighten the air quality objectives. And the process of amending the AQO is based on scientific background research and then also large-scale consultation. I appreciate the chairman's concern. If you amend the AQO, you will affect the industries. You may affect the economic costs, and we have to see whether it is a reasonable situation. So I think we have to rely on the past practice, that is the administration will go and consult the ACE and the public before you would make corresponding amendment to the air quality objectives. And during the process, we have always asked the question whether these amendments are best practicable means and whether there will be financial implications on the industry and the society. So, Chairman, theoretically, this is a very stringent process and it will take due time. So you should allow time for the Legislative Council to scrutinize it. Chairman, I think you put it very well. It is not just like adjusting the tunnel tolls, which affects the public. But those things are not that complicated and you can amend it by way of subsidiary legislation. So that's why I'm debating myself whether I would agree to this proposed amendment or not, because with the amendment it will be only subject to negative vetting. Well, if you use subsidiary legislation, there is also a timetable for us to complete the scrutiny. So the question is how to strike a balance. So for the past, if we look at the government's way of action and also the work of the current government, I would agree to have this proposed amendment because it is a very critical, important amendment to the ordinance. You are going to empower the Secretary to amend the AQOs in a quicker pace. And you would let the Legislative Council scrutinize the amendment as well. So this is my personal view towards the air quality objective. And I accept the amendment proposed by you because I can see that in the past you have been undertaking a due process, consulting the public and the Legislative Council before you amend the AQOs, which will affect the public. Chairman, that's why, as the chairman of the Bills Committee, I want to point this out. This is a critical matter. I think it is up to individual members to decide whether they would accept it or not.
All right. Next section. Section 46 amended, limit of time for laying information. Section 46 brackets 1 after in respect of an offense, we add other than an indictable offense. One of the penalties is under the indictable offense. And the time bar is different. In this case, in the case of an indictable offense, there is no time bar. For the entire APCO, there's a time limit or time bar in relation to prosecution. In relation to closure notice, there is no time limit, however. So we add brackets other than an indictable offense. Ms. Doreen Kong mentioned the time bar in relation to laying information. In the entire APCO, the time limit is set out under Section 46. I'm not going into details. When we lay information, there's no limit of time in relation to closure notice. That's why we need to make it clear. We add brackets other than an indictable offense. So under Section 46, there used to be a limit of time, but then we add an exception that is other than an indictable offense. That's what we mean. No limit of time for indictable offenses. For Section 30H brackets 2, we already set out that this is an indictable offense. Under Section 46, we just want to make it clearer. We want to make it consistent. So it means when the authority or when an authorized officer has laid information in the case of an indictable offense, there is no limit of time. That's why we need to make it clear. So you need to ensure consistency for one, for another. You want to enhance the deterrent effect in relation to closure notice, and there is no limit of time. That will enhance your prosecution power. If we didn't add this line, then there would be a limit of time. That's why we need to make it clear. In the case of an indictable offense, there is no limit of time. An indictable offense doesn't have any limit of time, and we are making it clear in this case. Mr. Chen Siu-hong, thank you. Same question. It's clearer with this line. Otherwise, there may be misunderstanding. That is, are indictable offenses also subject to a limit of time? Yes, this is clear, I agree. I have a question, though. In other bills committees, I observe the Chinese word 狗法, that is, lay information in the English version in this bill. The DOJ said that in many ordinances, the word 狗法 in the Chinese text, meaning lay information is used in many ordinances. In the English version, however, this is clearer, that is laying information. It is simply the conveying of information. So is there any more appropriate wording or phrase? Of course, I understand the DOJ has already responded to me in other Bills Committee's meetings. This is the conventional way of drafting, but to members of the public, they may interpret this word "gofat," that is lay information in the English version, in different manners. Well, to be accurate, does "gofat" in Chinese, that is lay information in English, mean criminal prosecution? Well, in general, the public may understand this as lay information means laying information against a particular person. That is as a way of tip-off. Well, the word "gofat" in the Chinese version is used in other ordinances as well. We want to make sure there is consistency in the laws of Hong Kong. That's why we use the Chinese word "gofat" in this ordinance as well, and that is laying information in English. In this case, will it cause any confusion to the public? We may supplement further information. We'll give you more information about in what ordinances we have used the word "gofat" in Chinese, and that is laying information in English as well. Next. All right, Section 48A. As we mentioned in this amendment, we want to add defense of emergency. So after Section 48, we have added 48A, brackets 1. In the APCO, for some sections, that is Section 10, bracket 7, as well as other sections, there are defenses of emergency. And the defenses are covered under Section 48A, brackets 2. That is, brackets A, the prevention of injury to or the saving of the life of any person, brackets B, the prevention of damage to any property in an emergency situation, brackets C, the prevention of a serious interruption or disruption to any public transport systems or public utilities in an emergency situation. These can be used as defenses of emergency. In brackets 3, the prosecution will have to provide evidence. That is, sufficient evidence has to be raised. 48A, brackets 4. If a person commits an offense mentioned in subsection 1 before the day on which this section comes into operation, this section, that is 48A, doesn't apply in relation to the proceedings for the offense brought against a person. If someone wants to invoke 48A and raise a defense of emergency before the amendment comes into operation, this is not allowed. Mr. Chen Xiu-hong, I'd like to ask about 48A, defense of emergency. This section applies to Section 10, 7, and so on. So why don't we include Section 30I as well? In some emergency situations, someone needs to enter the premises. Yes, indeed. We already have 30M, which covers 30I, L, and K. Actually, 30M is rather wide in scope. That's why it can cover 38A as well. For 30I, like 30M, the defense of emergency should suffice. That's what we were told by the administration as well. I understand you have added 30M, so from the perspective of drafting, we thought that you had missed something, but then in specific provisions you added these parts, and when one reads the legislation, one may be misunderstood. I mean, one may misunderstand the provisions. From the perspective of drafting, if you want to make it clear or succinct, Section 48A already refers to all cases of emergency being put up as defense. I understand your point, Mr. Chen. As I mentioned, Section 30M is wider in scope. It applies to Section 48A as well. If we did so, we would narrow the scope of Section 30M. Section 48A refers to emergencies. So, would you make it that Section 30M includes Section 48A as well? Because when I read, I find that it seems Sections 30I-KL are left out. The ordinance is quite an extensive one. It's rich in contents. And this time round, we added the closure notice, which is a significant part of the bill. Then we have H, I, J, K, L as well. For the newly added power of the executive arm, as well as the crimes that can be invoked, say the fine of $200,000 and the imprisonment terms, how do they compare with the APCO or other crimes under the APCO? Well, they are on the same par. That is a penalty of $200,000. That's exactly where the problem lies. In the statutory defense, if we make it less strict, then there is proportionality. Why are the closure notices more lax in this regard? Well, I'll try to take this question. Dr. Frankie Yan mentioned a point. After a fire, in an investigation, if a member of the public enters the premises at the request of a fire officer, of course, we'll have to have regard to the actual situation. Section 30M provides for a reasonable excuse, and we find assisting in investigation a reasonable excuse. In emergencies, Section 48A, however, these are matters of life and death and the loss and damage of personal property. These are emergency situations. So indeed, 30M is wider in scope. And we find these situations suitable scenarios for members of the public to use these situations as defense. Well, Mr. Doreen Kong mentioned this. Do we still need to first prosecute the person and then ask that person to raise any reasonable excuse? We'll have to see if the person has any reasonable excuse. If there is a reasonable excuse, we probably won't proceed with prosecution. However, in some cases, we have reviewed the case and we find that the reasonable excuse is not sufficient, is not appropriate, or is not reasonable, then we'll proceed with prosecution. Then in the court, we'll see how the magistrate makes a decision. That is, whether the evidence adduced by the prosecution is sufficient or not.
Legal advisor. Thank you, Chairman. 2 points to supplement. For Section 48, we have added some defense for emergency. We have asked them whether the common law defense of reasonable and honest and reasonable mistaken belief will be taken as a defense. Administration says yes, and it is up to the prosecution to prove to the contrary beyond reasonable doubt. So this arrangement is the same as Section 30M that members have just scrutinized. The second point, when the administration responds to members, they're saying that for Section 30M, it is wider in scope, and they have reasonable excuse as defense. So it includes Section 48A. But I want to clarify that the wider scope of 30M does not mean that Section 48A, the defense, will be applied. Because for Section 48A, we're talking about emergencies here. And it may become a reasonable defense. So that's why Section 30M can be applied. So this is a more correct way of putting it. I hope members would take that into account. Well, at the last meeting, and just now I raised the same point, it is now put indirectly that Section 30M is wider in scope. I think the legal advisor has put it very clearly. I think we have to look at the flow of the drafting. It is quite convoluted now and not very direct. Well, since these are new provisions to the ordinance, is it possible to make a reference to Section 30I, etc. under Section 48A? That is, when you enter the premises after it has been closed under emergency, that scenario will be included. Any response? Mr. Lai? Well, thank you, Chairman. From the drafting point of view, if there is a major principle that has been mentioned earlier in the bill, say we're talking about 30M here, we have defenses mentioned there, and then when we move on to specific scenarios, which will not affect the wider principle mentioned earlier, then from the drafting point of view, we would add a provision whereby, notwithstanding the previous scenario, then the following events will be covered. So what we would use is the wording without limiting a certain earlier section. And that means it will cover the defense coming on in the later provisions. That is a way of drafting too, Chairman. Well, I think the administration has explained about the situation. It will be up to members to decide. Let's move on. We want to amend Section 50 about the service of notices. It is stated that how the other notices under the ordinance will be served. We want to add Section 30D here, that is the issue of the closure notice. There is a way of serving that notice. So that's why we have to add in Section 30 the wording of except Section 30D. Because for the other notices, they will follow the existing way of being served. Next. Mr. Chen. If we look at the section here, you're talking about the service of notices under Section 50. So you are actually referring to Section 30E, but now you refer to Section 30D because 30D refers to 30E. And then in 30D, Section 30D 3A. So you just refer to Section 30E here about the service of closure notices. So you mentioned 30D here. Does that mean that by adding 30D, you would include 30E, right? Because in 30D, it is stated that the notice has to be served in the way mentioned in Section 30E under Section 30D3A. Is that correct? I think to avoid ambiguity, maybe you should add except Section 30D and 30E here under Section 50. Would it be better that way? Let's move on. We want to amend Section 78 on defenses. For Section 78, it is applicable to asbestos work, and it is similar to Section 38A. Well, one of the provision is saying that if any property is being damaged, it's not mentioned. So to tally with Section 48A, we propose an amendment to Section 78(1)(a) to add the wording, placing any property in danger of being damaged. For Section 78 bracket 2, we replace the word fact by matter. We just want to have a clearer indication here. And then after Section 78 bracket 2, we add Section 3. The purpose of adding Section 3A and 3B under 78 is that because in 78 there is a defense, and we want to mention that before the ordinance comes into operation, then the sections can continue to be applied for previous cases. But when the new ordinance come into place, then the new provisions would also come into operation. So that means the property in danger of being damaged will be included as well. That's the purpose of Section 3A and 3B. Mr. Chen Siu-hong. For Section 78, it covers defenses, and it is applicable to asbestos works. But for Section 48A, and what's the relationship of that with Section 78? Because the previous Section 48 talk about emergencies. For 78A, it is talking about in an emergency situation, something can be done. So that means the person can conduct some activity within the premises, even if it is closed. And they are not allowed to do so. In Section 48A, you have A1, and you cover Section 69 bracket 9, and also Section 79 bracket 7, and also Section 73 bracket 2, and they all cover asbestos. So I would like to know the purpose of drafting Sections 48A that way, because you're both talking about emergencies here, both 78 and 48 sections. So my impression is that in some cases you talk about emergency in different scenarios, but when you respond to my point about the relationship between 30M and 48, you said that have been included and there's no need to repeat it in 48. scope of 30M is wider and will cover the scenarios. So you don't need to repeat 30I, JL, etc. I think Mr. Chen is trying to touch upon the clarity of the legislative provisions. These are technical amendments. Do you have any response? I think we'll go back and look at the provisions, Chair. For Section 78A, it is talking about the removal of asbestos containing material. But for Section 78.2, they are not talking about the procedures for removing asbestos. But what about Section 69, bracket 9? I think 78 is specific about the removal of asbestos containing materials. But anyway, we'll go back and look at them. Mr. Tony Chair. And I would like to understand more about the situation. For Section 78, bracket 2, you use the word matter instead of fact. Is it because you have to prove the matter? What is the purpose of the change in wording here? Can you give us some examples as to why you need to change the wording? We just want to make the things clearer. There is no particular objective behind the change of the wording here. Our way of considering the matter has not changed. We just want to use a new wording to make the provision clearer. There are no other reasons behind it and no hidden meaning. So that means you are more restrictive in the past when you use the word fact. But now it seems to me that you are being more lenient in using the word matter. I think in the English version, you change it from fact to matter. Well, Chairman, I think your understanding is correct. In the past, the wording of fact is narrower because it has to be a fact. But now we're talking about a matter. So the extent is looser in a way. Mr. Chen has pointed out a very good point. For Section 38, for the amendments concerning defenses, I think you're just trying to be in line with Section 77. Is that correct?
淨係77條啫喎，我理解係。
係咪啊？即係唔會話影響其他嘅。
It's only Section 77 that will be affected. Other provisions will not be affected, correct? Yes, that's correct. Only Section 77 will be affected. Mr. Chen Siu-hong? Chairman, I don't have any question. Well, we have to make it clear. There has been some discussion about the amendment to Section 78, but for Section 78, it is only the defense for a person charged under Section 77, which concerns premises for asbestos works. So is there any other material changes apart from the proposed amendments? Have you consulted the trade concerned? It may be good amendments for the trade, but have you consulted the trade concerned? Because you're talking about asbestos work here. Because so far we have been focusing on cement works. We had a committee on asbestos management committee, so we will consult them on the amendments. Please conduct thorough consultation. Mr. Chen, any further questions?
好。
All right. We have finished scrutinizing Section 78. Let's proceed to Schedule 1. This is a major part as well. we need to amend the definition or to enhance the definition for cement works. In Schedule 1, specified processes, it is item 3. So we're going to divide it into A and B. A is already in the ordinance. However, for B, we use the production scale as the basis and to provide more figures. The purpose is to avoid misunderstanding. Let me first start with B, because A is already in the ordinance. For B, what is the definition of cement works? The total bulk storage capacity exceeds 50 tons. Or 2, the total installed capacity of concrete mixers exceeds 3 cubic meters. Or 3, the total hourly concrete production rate exceeds 20 cubic meters, expressed as volume of concrete per hour. And in brackets 2, we further explain the total bulk storage capacity, whether connected to any operational equipment involved in the operation of the works, whether temporarily or permanently, it is considered to be the total bulk storage capacity as well. This is provided under brackets 2a. In brackets 2, brackets b, we explain installed storage facility. A storage facility on land, including a storage facility on a mobile storage tanker connected to the relevant operational equipment, or to a storage facility on a ship or barge. These are considered installed storage facilities as well. I'll pause right here. There are subsequent requirements, so I'd like to see if members have any questions. Well, probably we can proceed to bracket C first. All right, thank you, Chairman. If the total storage capacity of all storage facilities on a mobile storage tanker connected to the relevant operational equipment doesn't exceed 50 tons, that storage capacity may be excluded from the calculation of the total bulk storage capacity. If the storage facilities on more than one mobile storage tanker are connected to the relevant operational equipment at the same time, the total storage capacity of the storage facilities on only one mobile storage tanker may be excluded from the calculation of the total bulk storage capacity. In relation to the silo, if in fact we only have 30 tons instead of 50 tons, we don't consider in fact how much you store inside the facility. We only take into account the absolute space or volume. For brackets 4 and 5, for the purposes of paragraph 1b2, the total installed capacity of concrete mixers is the total capacity of all concrete mixers installed for the production of concrete. If there are 5 in a plant, so 3 times 5, a total of 15 cubic meters. 20 cubic meters per hour, and that is the maximum total production output capacity of concrete per hour. That is the amendments to be made to Schedule 1 in relation to cement works. The amendments are aimed at preventing misunderstanding. Mr. Chen Siu-hong. Thank you, Chairman. I'd like to ask about the Chinese and English texts. We have total bulk storage capacity. I don't have a lot of experience in this field, so I'm not sure if we all understand what it means. In English, it is total bulk storage capacity. It seems to me the English version doesn't tally with the Chinese version. In relation to cement works, in a construction site, you can see bagged cement in construction sites. So what does bulk cement means? It means it is not a bagged cement. It is transported in a vehicle to a construction site, hence the name bulk storage. So if one transports cement not in the form of bags, then we don't count that in. That's why we use the word bulk in the ordinance. Can you tell me once again? In the in a premise that handles cement, cement is transported on different vehicles, or cement is carried to construction sites in bags. We have already talked to the trade for bagged cement. It is not included. That is for packaged cement. It is not included. We don't consider these. We don't count them in. Well, in the English version, I understand that it's clear, total bulk storage. However, in the Chinese version, it is not as clear. If one says that I need cement, probably I will be given bagged cement. Well, we have the translation for bagged cement and bulk cement under the Air Pollution Control Construction Dust Regulation. We call that bagged cement. For bulk, that is non-packaged cement. Well, the industry can tell the difference between bulk and bagged cement. Whether in Chinese or in English, the industry understands what they mean. Mr. Benson looked. In Schedule 1, 1AB, I have a question in relation to drafting. 1A brackets 1, 2, 3, you use semicolons. That is or after brackets 2. For 1, 2, 3, you use or. So other one from the 3 items under A and other one out of the 3 items under B. Can I see it this way? Yes. Because you have the word or in A, whereas you don't have or in B. Right, yes, semicolons are used, so you see the word or in brackets 2. Alright, 50 tons is a weight. 3 cubic meters is the capacity of the concrete mixers, and the total hourly concrete production rate is 20 cubic meters. So how much tons or how many tons for 1 cubic meter? For 1 concrete mixer, that is 7 to 8 cubic meters. For 3 concrete mixers, well, per cubic meter, how heavy is it? Well, we'll have to do some calculation. Around 2 tons, is that right? 20 cubic meters, around 2 tons, is that what you mean? Well, for 20 cubic meters, that translates to 40 tons, because 1 cubic meter translates to 2 tons. And I'd like to know what connected means. Do we need to see pipes? Yes, pipes. For concrete mixers, they are usually in a plant. Concrete mixers carry concrete, and then they pump these concrete into the plant through a pipe. In other words, if there are 10 vehicles, 10 mixers, but there is a one pipe connecting a vehicle, is there any way for the person concerned to use the loophole? Well, we have already talked to the industry. They agree that one vehicle is allowed. If there are more than one vehicle, then the figure will exceed the figure set out in the bill. So we have already struck a balance in our discussion with the industry. For one concrete mixer, it can carry as much as 30 tons of concrete. If we only take into account one concrete mixer that is connected, so that's why you use the total hourly concrete production rate to forbid the industry from using different vehicles, more than one vehicle. Is that correct? Well, you need gravel, water, and other materials to prepare concrete. As we mentioned, the concrete mixer and the concrete production rates can be quantified so that we'll decide whether a license is needed. If one meets the requirements of brackets of 1A, either 1, 2, 3, and meets the requirement in either one under brackets B, one will have to obtain a license from us. So in relation to the definition of specified processes, you are confident that you can prevent anyone from exploiting a loophole. Is that correct? Yes, that is correct. We have added brackets B, brackets 2 and 3. And when we met with the industry, we have discussed this point and we have arrived at the figures 3 cubic meters and 30 tons. They consider these figures reasonable. That's why we have decided to use these figures. Mr. Chen Xiu-hong. In relation to the definition of specified processes is rather important. Just now I heard from the administration. In our meetings, we understand that the administration has already discussed with the trade, so this is acceptable. We understand why we need both the capacity as well as the production rate. I'd like to ask about the point mentioned by Chairman, connection, connected to. The first vehicle is not counted. When a first vehicle is connected to operational equipment, then that vehicle isn't taken into account because that vehicle supplies concrete and materials or supplies concrete materials. If the total bulk storage capacity exceeds 50 tons, if we still count that vehicle in, the figure may exceed 50 tons. That's why in our discussion with the trade, we allow flexibility for the trade. We count the first vehicle out. Well, this is reasonable because upon connection, when the figure exceeds 50 tons, then it will go beyond this prescribed capacity. I understand this point. However, in situations in which there are 2 to 3 construction sites adjacent to one another, if they don't want to get license, the total bulk storage capacity is 20 to 30 tons instead of 50 tons, they have a lot of vehicles connected to one another. This may not be economical, because for each construction site, if the figure is below 50 tons, one doesn't have to obtain a license. But what if there are construction sites connected to one another, when there are several concrete mixers connected to one another, and the first one is counted out? Is there any way for loopholes to be exploited?
Well, that's exactly the situation that we have discussed with the industry. Our consensus is that for the construction sites, generally, they would use the concrete materials provided by the other commercial concrete firms. But on the construction site, they will also conduct some piling works and foundation works. And then they would need to use concrete. So that means they would try to add water and then produce concrete slurry themselves. And they also have some equipment. So the equipment they are using are less than 50 tons, and they don't have to apply for a license for specified process. But they are worried that for the facilities, they would need to be reprovisioned with concrete. So they are worried that if they ask a tanker to come to provide concrete to the site, then they would pass the 50 tons threshold, and then they have to apply for a license. So that's why we allow the vehicle that is connected to the operational equipment to be excluded. It's a decision after our consultation with the trade. Well, I think this is a matter of concern to the industry. And since you have added the other two requirements under the definition, that is the concrete production rate and then also the capacity of concrete mixers, so you would be able to reduce the loopholes. If there are no further questions, we will complete discussion on this. Let's move on. Sorry, Chairman, can we have a toilet break? It's now 11:17. Let's resume at 11:25.